Now we're joined by Matt Mangino via Skype. How are you doing, Matt?
Great.
Good. And we still have Jason with us. So I want to, first, Matt, you're the newest guest, so let's throw to you first. We have the doctor here testifying as to the injuries that they saw firsthand. What do we make of this testimony, and what direction are we going here?
Well, it appears that the prosecution at least felt it was important enough to present this rebuttal testimony based on the testimony that was presented by the defense in this case. And they're making sure that the jury understands, what the extent of the injuries were, and that this was not the type of injury that could result from a fall, but this was, an abusive type traumatic injury, and they want to emphasize that to the jury.
Matt, anything to add, or anything that you see as this witness is on the stand testifying to the numerous injuries from this young child?
Yeah, it is strange to hear from a physician talking about injuries that are essentially all over the child's body. 62 or 64 exhibits when we broke away depicting what the victim looked like in terms of the injury. But again, it is a matter of what injuries caused her death. And the prosecution has to prove beyond a reasonable doubt that those injuries were, in fact, caused by the defendant in this case.
Now, Matt, we heard in the defense attorney's opening, they cannot prove that my client did these actions. What do you think we can anticipate from a cross-examination from the defense after the direct is done?
Well, I think one thing that's going to be looked into is the bruising, the age of the bruising. When did this bruising occur? Did it all occur at the same time? I think that is significant. I mean, this testimony so far is interesting on so many different levels. It's kind of a narrative by this expert witness, this doctor. Your viewers often hear about leading questions. This is a witness leading the attorney in this line of questioning. But they're talking about bruising and injuries. Yeah. We're not getting to the fundamental point here. What caused her death?
And I'm sorry.
We'll hear that from a forensic pathologist.
Now, Matt, a few minutes ago I had to cut you off because we had to go to break, but I want you to finish that thought and kind of expand on it, because I knew you were going, and I definitely want our viewers to hear it as well.
In this situation, when you're looking at or listening, to this testimony, you have to make some determination of, what is proper and what's improper, so to speak. There are no objections. The defense has not objected in any way to this testimony, although it is unusual. It's a narrative by the witness with few questions by the prosecuting attorney. You have to figure maybe the defense thinks this testimony is helpful and doesn't want to interrupt it and wants this witness to keep going on with their narrative because it's potentially helpful to their case. We'll have to see how that sort of unfolds as we go forward.
Do you think we might be kind of just before that huge aha moment where the defense attorney is saying, because I agree with you, there's not a lot of objections, and I think to your point earlier, it's almost like the witness is marshaling in this evidence. It's very little participation from the prosecutor. It's like this witness is just, in my eyes, just great, just giving everything you need. There's no objections, good flow. I mean, we can't see her to kind of judge how she comes across, and we can't see how the jury is reacting, but I think she's doing a good job. Would you agree?
Well, she's doing a good job, in this narrative. But if I was the prosecuting attorney, sometimes it's too good to be true. I'd be looking over at defense counsel and say, why aren't you objecting? Why don't you have any concerns? Why aren't there any issues? You have to start to believe that the defense likes what they're hearing. And it's unusual to hear things like a history, a physician talking about getting a history in a homicide case. And in this particular case, she just revealed that history came from the father, who may very well be someone that the defense points at in this case. So, this history and this testimony that grew out of this history, in her opinion that did, may be something that backfires on the prosecution in this case.
So to the 2 points, Matt. One, the information is coming from the father. What are we to get from that?
Well, that's significant because the witness had testified that she based an opinion that she's going to provide on a history that she took, and that history obviously didn't come from the child, but it came from the child's father. And so the child's father provides information. Hey, the child was fine the night before, and then this terrible thing happens the next day. Is there some bias there? Is there going to be an effort to point the finger at the father and say, hey, he told us that? He gave that history because he wanted to protect himself. So those are important issues for the defense in this case.
So here's a prosecution doing a very common act that most lawyers do that you might see in court. And if you're unfamiliar with it or you don't date a lawyer, this is how it works. It's called IRAC. It's here's the issue, here's the rule, that being the law, I'm applying, and here's my conclusion, Judge. This is what I believe these records should be, this is what the law says, and this is why I should get it. Matt, what do you make of this? Why are we talking about logs, and why are we interested in who visited the defendant and whether it's their mother, their lawyer, their sister, their girlfriend, their boyfriend? Why?
That's an interesting question. It's unusual to see a prosecutor making a public records request based on information that they want about a defendant in the case. And you hear him talking about, hey, this is a public record. These logs of coming into the jail are taken down by the sheriff or sheriff's deputy. So this is information that should be accessible by a public records request. There's no exemption to any of these records that they're requesting, and they should be turned over. What significance it has in terms of the prosecution of the case is another story. So, maybe they're looking to see, based on other motions that they filed, are there mental health professionals coming into the jail? Are there psychiatrists coming into the jail to visit? They want to see, if they're preparing for some infirmity defense with regard to insanity or even mitigation with regard to ultimate sentence.
And I'm actually being told that while you're bringing that up, Matt, that you actually hit the nail on the head. It's actually about the mental professionals who've come and visited. So I think what they might be trying to do, and like what I always tell people, trials are 1 inch by inch sometimes. It's not usually the biggest witness or the biggest steps you make, but if you can figure out what mental health professionals visited, how often, and then you can kind of backtrack and get more discovery. I think that's maybe what they're trying to get at. Again, I don't want to give them more credit than they deserve, but that's what makes the most sense here. So if you notice, we've shifted from going to the direct of this doctor now to the cross-examination. The defense attorney is going to have the opportunity to poke holes, look at where there might be flaws. Matt, I know that both you and I are signing off in a few minutes, but my question for you is, what do we expect to see here on this cross-examination?
Well, I think just what we mentioned a moment ago, and that is, what did this witness opine? Her opinion, to a reasonable degree of medical certainty, was on a very narrow issue, although she testified about a lot of different things. And I think the defense came right out and said, hey, this is your opinion. This is something that we're going to talk about, because I think that's, where they're going to be able to show that, hey, there was a lot said, but there wasn't a lot of substance. And I think that's extremely important.
Exactly. And not only that, but the breadth of her knowledge and her opinion as to all of these issues comes from 4 out of, I think they said, 500 or 5,000 pages. I mean, right. In high school, I might have only read the first chapter of the book, and then I went into class and said, yeah, teacher, I know the whole book. But on trial, you can't do that, right?
Right. Well, in this instance, Attorney General Barr did a much better job putting out 4 pages in a letter compared on 500 pages of the report. She's got 4 pages and 5,000 pages of report. So I think they're going to try to poke holes at, your opinion has been based a lot on your experience with regard to other patients and other situations. She even said it right on cross-examination to begin with, that this is what I normally see.
Exactly.
That doesn't cut it.
Exactly.